Hello everyone, welcome to another series of In News. Today's topic of discussion is why is the center opposing same-sex marriage? First of all, we will have a look at the news. Then we will discuss what is same-sex marriage, what is the recent stand of the center, what is the stand of government regarding same-sex marriage, why does the government oppose the move, way forward, and practice questions. So first of all, let's have a look at the news. The Supreme Court heard arguments on behalf of the government from Solicitor General Tushar Mehta in the case seeking legal recognition of same-sex marriage. Now let's discuss what is same-sex marriage. Same-sex marriage is marriage between partners of the same sex and or gender identity. For example, a marriage between two men or two women. Now let's understand what is the recent stand of the center. To leave the issue to Parliament, and the Special Marriage Act cannot be redrafted again to allow same-sex marriage. What is the stand of government regarding same-sex marriage? The court had only decriminalized sexual intercourse between the same-sex persons in its 2018 judgment in Navtej Singh Johar versus Union of India and not legitimized this conduct. The government argues that marriage depends on customs, rituals, practices, cultural ethos and societal values. Same-sex marriage cannot be compared to a man and woman living as a family with children born out of the union. The Parliament has designed and framed the marriage laws in the country to recognize only the union of a man and a woman. Registration of marriage of same-sex persons would result in a violation of existing personal as well as codified law provisions. The Special Marriage Act of 1954 provides a civil form of marriage for couples who cannot marry under their personal law. The government argued that any deviation from this norm can only be made through the legislature and not the Supreme Court. Now let's understand why does the government oppose the move. Religious definitions of marriage. Various religions have always recognized marriage only between a man and a woman. If a new idea of marriage has to be imagined, then it must be Parliament and not the court which can create it. It is essential to note that marriage, even under the Special Marriage Act 1954, originates in personal law. The said secular enactments were enacted not as a means to create a new social legal institution, but rather as a means to overcome some limitations of religious personal laws. Legitimate interest of state. The state has a legitimate interest in regulating marriage. The right to marry is not absolute and is always subject to the statutory regime provided by the competent legislator. There are several aspects of marriage which the state has regulated, such as age of consent to marriage, prohibition of bigamy, prescription of prohibited degrees of marriage, which means one can't marry their lineal ascendants such as parents, grandparents, etc., judicial separation and divorce. The state can claim legitimate interest to regulate when to marry, how many times to marry, whom to marry, how to separate, etc. If the petitioner's argument were to be accepted, the law on bestiality or incest can also be challenged on the same grounds that the state cannot regulate personal relationships. The bench agreed with the center that an absolute statement that the state can have no interference in regulating personal relationships might not be correct. The right to privacy. In the landmark 2017 decision recognizing the right to privacy as a fundamental right, the Supreme Court had held that sexual orientation is an essential component of identity. The center argued that while the right to privacy exists, it cannot be extended to marriage. When consulting adults want a societal acceptance of the relationship by way of marriage, the center argued that they are conferred with a public status by the state. Parliament must decide. The center has repeatedly said that the decision on same-sex marriage can only be made in Parliament. The argument essentially is that there exists a democratic right of people to regulate themselves and that it cannot be mandated by a court. A string of rulings from the US Supreme Court, including the 2022 Dobbs versus Jackson case on the limits of judicial review. In the Dobbs ruling, the US Supreme Court held that abortion neither finds express mention in the US Constitution nor is deeply rooted in the nation's history and tradition. Therefore, cannot be a protected constitutional right. The center also argued that the court will be venturing into unknown arenas if it legislates on same-sex marriage. That could raise several unintended consequences in law. As per the information available in public domain, there are a total of 72 categories of genders falling within the LGBTQIA+ community. This would mean several permutations and combinations of marriage and fact-specific peculiar problems arising therefrom. It will be impossible for the court to conceive all such permutations and combinations upon whom the socio-legal recognized relationship of marriage would be converted and provide for detailed mechanism or provision to deal with such situations. Interpreting the law. The key argument of the center is that the court cannot interpret the Special Marriage Act to include same-sex marriage in a meaningful way. The court will have to examine the entire architecture of the act rather than examine a few words like husband, wife, etc., mentioning several instances where simply replacing the words wife and husband with person would not be compatible with the rest of the legislation. There are instances where the law provides specific rights to a wife. For example, the law says that the wife acquires the domicile of the husband upon marriage. So, who will be the wife in a same-sex marriage? And also the issue of divorce. Under the Special Marriage Act, a wife may seek divorce on the ground that her husband has, since solemnization of the marriage, been guilty of rape, sodomy, and bestiality. This is a right specifically given to the wife. In case of a gay marriage, who would get this right? The petitioner's argument is that the court must allow both the parties to have this right. But there is a problem there. Can the court allow a right to one party in a gay marriage and not to party in a heterosexual marriage? Now, effect on personal laws. The center argued that personal laws will inevitably be affected even if the court only looks at the Special Marriage Act. Before the arguments began, the court made it clear that it will restrict the scope of the challenge only to secular laws and not religious laws. However, it might not be possible for the court to interpret the Special Marriage Act in isolation without touching personal laws. Under Section 19 of the Special Marriage Act, the parties married under the secular law lose their right to family property, although they will continue to be governed under their personal laws in all other aspects such as divorce, inheritance, and adoption. Now let's have a look at the current state of marriage equality. There are currently 34 countries where same-sex marriage is legal. Andorra, Argentina, Australia, Austria, Belgium, Brazil, Canada, Chile, Colombia, Costa Rica, Cuba, Denmark, Ecuador, Finland, France, Germany, Iceland, Ireland, Luxembourg, Malta, Mexico, the Netherlands, New Zealand, Norway, Portugal, Slovenia, South Africa, Spain, Sweden, Switzerland, Taiwan, the United Kingdom, the United States of America, and Uruguay. Now lastly, let's discuss about the way forward. India is a culturally diverse country with different religious and societal values. Any legislative or judicial decision on same-sex marriage must consider the cultural sensitivities of different communities while also ensuring that the fundamental rights of individuals are protected. India still has a long way to go in terms of social acceptance of the LGBTQ+ community. Education and awareness campaigns should be developed to promote acceptance and understanding of heterosexuality, then same-sex marriages should be considered on table. India is a signatory to various international human rights treaties and conventions which require it to protect the rights of all individuals, including the LGBTQ+ community. As many other countries such as Canada, the United States, and Australia have recognized same-sex marriage, it is imperative that India legalizes it to ensure equal rights and opportunities for all individuals regardless of their sexual orientation. Now it's time for the practice question. This question was asked in 2019 exam also. Question is, which article of the Constitution of India safeguards one's right to marry the person of one's choice? Article 19, Article 21, Article 25 or Article 29? Send the answer of this question in the comment section. Stay tuned for the next episode. Thanks for watching.